Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
Hi, I'm Michael Krznaric.
Welcome to Hull on Estates. You're listening to episode number 655. Today, we're going to be discussing a recent decision out of British Columbia that deals with issues of capacity and guardianship, and maybe highlight some of the key things we should be keeping in mind when we're assisting clients with those types of matters. But first off, I want to welcome you, Michael, to podcasting. This is your first podcast with the firm, and I'm happy to be sharing that experience with you.
Thanks, Nick.
And we're also gearing up for the holidays right now. So if you're watching this podcast or listening to this podcast while you're off on vacation or enjoying some time with the families, we wish you all the best, and hope you're having a nice break. So I think first off, Michael, maybe if you can walk us through just some of the basic facts of this decision. So we're looking at the Re Sandhu decision. It's 2022 BCSC 2027, and we'll include a link of it to the decision so that you can read it yourself if you're interested in the podcast description. But let's just take a look at some of the facts we were dealing with here.
Sure. So in this case, we had a petitioner, and he tried to file a petition under the BC Patients Property Act, and he wanted a declaration that his father was incapable of managing his affairs. And in BC, the law requires two medical opinions that declare someone incapable before they'll appoint a guardian over their property. And in this case, there was actually three assessments done. So we had one assessment done at a hospital, but it didn't really speak to the capacity of the father. Then we had a second opinion that was actually organized by the son, and it actually declared the father to be incapable. And then we had a third opinion that was organized by the father's lawyer, and this opinion declared that the father wasn't incapable. So the son only had one opinion that declared his father incapable, but he still wanted this application to go through to have his father declared incapable and to be appointed as the guardian over his property. So in the end, the decision actually, the court decided that the father wasn't incapable, and for a variety of reasons that I don't think we'll get into now.
Right. So yeah, it was an interesting decision to me, at least, because in a lot of these guardianship type applications, we don't see any response from the person who's allegedly incapable. So in a lot of them, we're going ahead, the incapable or alleged incapable person is served with the materials, but most often don't respond. So in situations like this, where they do respond, where they hire a lawyer who I assume in this situation was satisfied that they were capable of retaining them to provide legal services and to represent them in court. I mean, that obviously plays a pretty big role in I would think, the way that the matter would progress and likely the outcome of the decision. Just backing up a bit too. So I know, Michael, we were talking about declarations of incapacity. So that really the court's the only entity that can make a declaration of incapacity. So that's what the son was seeking here. And of course, with those conflicting reports, the court was tasked with, okay, what do we do here when we see some evidence that this man is incapable? He'd been having some medical problems, some falls. There was concern expressed by the son as to the way that his financial affairs were being managed, and possibly some money that had been misappropriated or missing. And so we see the court looking at this, and it's sort of, as a whole, I think the first point or theme we'd like to highlight is that courts, and this is important to keep in mind in any matter dealing with allegations of incapacity, whether it be a guardianship application or not, but courts are most often wanting to favor the least intrusive option when we're dealing with a person's personal autonomy and there's evidence that they may be capable. Courts often are reluctant to get involved. So here, I mean, in Ontario, under the Substitute Decisions Act, Section 2, we have a presumption of mental capacity for all adults. In BC, they do have similar provisions. And ultimately, I think the court was guided by that, the fact that this man responded to the application, as did his wife, jointly with him responded to the application, and just I think probably had what we would consider the right decision, considering there's a presumption of mental capacity, and we've got those conflicting evidence as to capacity.
I agree, and there were certainly some factors that possibly could have indicated incapacity. I believe the decision talked about how the father was scammed out of some money by a fraudster, how he got himself into legal trouble with the city of Richmond that involved him failing to comply with court orders. So there was some signs there, but in the end, as you spoke to, the court is going to rule in favor of the person that is being subjected to the incapacity if it's not crystal clear that there's incapacity. So in this case, there was factors in both directions, and we think the court made the right decision by siding with the father.
Right. Yeah. So that tends to be in line with what we see here in Ontario as well.
Yeah.
Just moving on, Michael. So I know you mentioned we had three assessments here, three opinions as to capacity. Do you mind sort of taking a look at those three again, and maybe we can try and figure out from that review why the court favored the one that ultimately said that the father was capable?
Yeah, sure. So the first assessment was done while the father was at the hospital. And I think the father was in a hospital for an unrelated medical reason. I think he may have had a fall or some sort of medical issue that brought him into the hospital, and an assessment was done. But this assessment really didn't comment on his capacity to manage his affairs. So the court really didn't take that assessment. They didn't put a lot of weight on that assessment. And so the second assessment was actually organized by the son. And this was done by an assessor that was chosen by the son. And the son had spoken to the assessor prior to the assessment. And the assessor was using a lot of assumptions that the son sort of spoke with him before the assessment was actually done. And this was done with a translator. I think that's important to note. The father did not have perfect English skills, so a translator needed to be used for this assessment. The assessor wasn't able to speak the native language of the father. So all of this, although the assessment came back stating that the father was likely incapable, all of this was viewed by the court as sort of devaluing this test because of all these factors that I just spoke of. So a third assessment was actually organized by the father's own lawyer, and this was done in his native language and sort of without the biases that the son had put within the assessor for the second assessment. And the third assessment stated that the father was capable of managing his own property. So really the court had the task of deciding which of those last two assessments were more valuable in this case. And I think unsurprisingly, they went with the last assessment. It was more recent. It was done in the native language of the father, and it didn't have the biases from the son. And it was without less issues, I would say, than the second assessment, given what I spoke of.
Absolutely. So I think that's a great summary, and just key points to keep in mind when we're assisting clients and we're asking for helping to arrange for a capacity assessment to be conducted. We want to make sure that it's independent. I mean, with the second assessment, I remember reading, and I think the court did consider the fact that the son not only arranged for the assessment, but he was within earshot during the whole thing. Mm-hmm. We want to make sure with the first assessment here, there wasn't a clear comment on the father's capacity to manage his property. So in the retainer letter to the capacity assessor, we'd like to clearly outline the legal capacity standards that we want to be considered, commented on, so that we get those responded to, and we actually get an opinion we can hopefully use on those issues. And of course, like you said, Michael, the latest assessment was the latest assessment. It was closest in time to the actual hearing. And our listeners will know that capacity is situation specific, task specific, and time specific. So a capacity assessment that's closest in time to the hearing application may be weighted differently according with that. So I guess just looking at the last thing we wanted to consider here. So not only are courts unlikely to intervene in someone's ability and independence in managing their property when there's conflicting evidence. But courts may even be reluctant to make an order requiring someone to submit for a capacity assessment. And that's something we see, of course, in Ontario as well. It's not an automatic right if a child has a concern about their parents' well-being. It is still something you need to go to court to, and there is a legal test. Michael, do you mind taking a look at the legal test we deal with in Ontario here?
Yeah, sure. So Section 79 of the Substitute Decisions Act. So the legal test is that if a person's capacity is in issue in a proceeding under this act, and the court is satisfied that there are reasonable grounds to believe that the person is incapable, a test could be ordered. But it's worth noting that many decisions have stated that this is just a minimum standard. It by no means guarantees that a test is going to be ordered. So I think, just as we were speaking with the issue of declaring someone incapable, I think the court is going to rule that unless the evidence is overwhelmingly obvious that a test should be ordered, I think they're going to shy away from ordering it, even if this test is met.
I totally agree. That's great. Thanks, Michael. So unless you have anything to add, I think that concludes our podcast. We want to thank you for listening and wish everyone a happy holiday season and New Year, if that's when you're listening to this. Again, I'm Nick Esterbauer.
I'm Michael Krznaric. Thanks a lot for having me, Nick, and thanks everyone for listening.
Of course, should you have any questions, please send us an email at info@hullandhull.com or contact us through the questions section in our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.